You were in a car accident. It wasn't your fault, and now you're stuck figuring out insurance, repairs, medical bills while the other driver's insurance company gives you the runaround. You think, should I call a lawyer? Do I need to file a claim with my own insurance? What if they blame me anyway? And if you don't get this part right, the claims process, you could end up having a ton of medical bills, car bills, and no compensation. I'm Guy DiMartino. I'm a personal injury lawyer in Indiana, and I help thousands of people over the years in the same exact situation. Most Hoosiers aren't car accident experts, so let's walk through the very first things you need to do before any paperwork or phone calls so you don't get stuck paying out of pocket or settling for less than you're owed. The number one priority is your safety. After the crash, if you can move your car out of traffic and check yourself and any passengers for injuries, but don't ignore aches and pains just because you aren't bleeding. Injuries like whiplash or concussions often show up hours later. Once you're safe, call 911 right away. Indiana law requires you to report an accident with injuries, death, or property damage over $1,000. The police will show up and file a report, which can become a key piece of evidence down the road. Even if the other driver begs you to just work it out between you two, don't skip calling the police. It protects your rights. While you're on the scene, gather as much evidence as you can. Use your phone to take clear photos of every car involved, the roadway, license plates, any obvious signs of fault like skid marks or broken traffic signals. Exchange information with the other driver, including name, address, phone number, their insurance information, make, model, and license plate of their car. If there are any witnesses, even people who just saw the aftermath, ask for their contact info. All this could be vital in proving that you were not at fault for the accident. And one more tip, watch what you say. Don't apologize or admit fault, even if you're just being polite. In Indiana, even innocent words can be twisted against you by the insurance company later on. Now that you're home and things are starting to sink in, your next step is calling your insurance company, even if the other driver is clearly at fault. Indiana law and most insurance policies require you to let your insurance know about the crash as soon as possible, because you're going to have to file a form downstate with the BMV, which says that you were insured or prove that you were insured after the accident. When you call, stick to the facts. The date, time, location, and vehicles involved. Don't speculate about who caused the accident or how badly you're hurt. Just give them the details that you know. Let them know if you already have a police report number. Typically, the police officer will give you a card with a police report number on it. Your insurance agent will explain what information they need next, and they'll let you know how your coverage applies. Many people believe you shouldn't use your own insurance at all if you weren't at fault, but that's not always true. And your insurance company, if you're not at fault, is not going to raise your rates. In Indiana, even though the other party may be responsible for your medical expenses in the end, in the beginning, that company's not writing a check to your hospital or your doctors to pay for your medical or hospital bills. The primary payer for your medical expenses is you. And if you have coverage under your auto policy for medical payments, that is the primary payer. What that means is your health insurance, Medicare, Medicaid will not pay any expenses before you use up that limit. You exhaust those insurance benefits. The other insurer is underinsured or uninsured or just dragging their feet. Your own coverage, like collision or uninsured motorist benefits, can step in and help you right away. For instance, many times you want to get your car fixed really quickly, but the other insurance adjuster is saying, well, I can't get in touch with my insured. We can't go ahead and make a coverage decision or a liability decision in this matter until I speak with them. And sometimes that could take days weeks or months, and you can be without a vehicle. The other side's not going to provide you with a rental car at that time because they haven't made a coverage decision. So, Indiana does require insurance policies to include uninsured and underinsured motorist coverage unless you have rejected that in writing. The other thing that you want to do is you want to keep notes of every conversation that you have with the insurer, who you spoke with, the date and time, what was said, save every letter and email, and take notes because later on, these conversations and what they said to you might refresh your memory if you have to go ahead and file a lawsuit or if you're involved in a dispute over the claim. If you're hurt, even if the injuries seem minor at first, you need to file a personal injury claim. Here's where Indiana laws become critical. Indiana uses a system called modified comparative fault. What that means is this. If you're found to be over 50% at fault for the accident, you can't receive anything. If you are found to be 50% or less at fault for the accident, then your recovery will be reduced by the percentage of fault. Let's say the other driver ran a red light, but you were speeding a bit. If the insurance company decides that you were 20% at fault for the accident, then your full value of your damages is $100,000 or $10,000. Then you would receive $80,000 or $8,000. The 100 or 10 would be reduced by 20%. That's why it is so important to gather good evidence and not say anything that minimizes the other driver's fault. To start your claim, you'll usually contact the out-fault driver's insurance company, or they will contact you and tell them that you're making a claim for your injuries if you were injuries and for your property damage, your vehicle. They may ask you for a recorded statement. Under the law, you are not required to provide them with one. And if you want, you can have a lawyer on the statement. These adjusters are trained to find ways to reduce or deny your claim, so be polite but cautious. Do not trust them. The insurance company may ask for copies of your medical records, proof of missed work, and estimates for vehicle repairs. Only provide what's necessary and don't sign any broad releases. It's smart to get guidance from an injury lawyer at this stage, even if you think the case is straightforward. Most folks who do injury work will provide you a few minutes of guidance and not require anything. Many lawyers in Indiana offer these free consultation and charge nothing, and if you decide to hire them, they only get paid if you get paid. While you're waiting for the insurance investigation, you still need to get your car back on the road. In Indiana, if you weren't at fault, the other driver's insurance should cover the cost of repair or replace the vehicle, but that doesn't always happen smoothly or quickly. Here's what usually happens. The at-fault insurer will send out an adjuster to inspect your car. They will then offer you a repair estimate. And if your car is totaled, they'll offer you the fair market value. Most of the time, the fair market value is not what the car is worth to you. It's what it's out in the market. If you need a rental car, Indiana law requires them to provide you with a rental car, but they always jerk around with the time that they're going to give you the car for because they know you can't go ahead and hire a lawyer over a dispute of whether you should get 5 or 10 days of rental coverage. If the other lawyer's insurance drags their feet, you can use your own collision coverage to fix your car. If you have rental coverage, you can use your own rental coverage. Your insurer may require you to pay the deductible upfront for the collision, but they'll try to recover that money from the other insurance company when they file a claim with them. One tip, don't rush to accept the first settlement offer on your car. Make sure it matches the true value of your vehicle in your area, not just a low ball number off a website. You have the right to negotiate. Now let's talk about what really matters. Making sure you aren't left with big medical bills or lost income when you weren't at fault for the accident. In Indiana, at-fault driver's insurance is responsible for your actual losses, medical bills, hospital bills, doctor's visit bills, therapy, prescription, lost wages, lost salary. pain and suffering, emotional trauma, loss of enjoyment of life, and any future medical services that are necessary and related to the accident. Most insurance companies will always try to settle the claim for less than it's worth because they can save money for their shareholders. They may offer you a quick check for your car repairs, but drag their feet on the actual injury costs, hoping you'll get desperate and accept less. Never accept a settlement or sign away your rights until you know the full extent of your injuries. Sometimes pains worsen over time. Sometimes you discover a more serious problem. Under Indiana law, you typically have 2 years from the day of the accident to file a lawsuit, but waiting can hurt your case, especially if you haven't gathered important evidence or witness statements. If your own insurance pays for any medical care or lost wages through medical payments, they may seek reimbursement from your settlement monies. It's usually not a dollar for dollar recovery if you have a lawyer. This is called subrogation. A good attorney can help make sure that you don't pay more than you owe and that your final settlement truly covers your needs. Let me give you a real life example. I once helped a client who got rear-ended at a stoplight on US 30 between Valpo and Maryville. The other driver's insurance claimed she must have slammed on her brakes, so they tried to assign her 30% fault and cut the settlement by 30%. But because the client took good photos, got witnesses' names, and didn't apologize at the scene, we were able to prove that she was not at fault, and the client recovered her full medical bills, some compensation for her time off of work, and a fair value for her pain and suffering. You might be wondering, do I really need a lawyer if my accident is clear and it's not my fault? Here's the truth. If your injuries are minor, your car damage is small, and the insurance company is treating you fairly, you might be able to handle it alone. But if you're facing any of these situations, you probably want to get help. The other driver denies fault or the insurance company refuses to pay you. You have serious injuries or long-term pain. You have multiple other insurance companies that are involved, Medicare, Medicaid, health insurance. The insurance company says you are partly at fault, even if you know that you weren't. You're overwhelmed by dealing with medical bills, missed work, and the confusing paperwork, and the insurance company is trying to pressure you to settle quickly. Typically, they'll say, I'm going to offer you this money. It's only open for 3 days. Yeah. Right. A good Indiana attorney won't charge anything unless you recover money, and they can often get you more, sometimes a lot more, than you'd get on your own. Just as important, they take the stress off of your shoulders so you can focus on getting better and going on with your life. So let's wrap up. Today, you learned exactly what to do after a not-at-fault car accident in Indiana. From the first steps at the scene, to reporting the crash, to handling insurance, to car repairs, to rental coverage, and to injury claims. You also discovered why it's so important to protect yourself, gather evidence, and never rush into a settlement. If you want to take the next steps to protect yourself, especially after something as scary as a truck accident, you may need to watch our next video. What should I do after being injured in a truck accident? That's where we'll break down the unique dangers and legal traps that injured Hoosiers face after a truck crash. Don't risk your health, your finances, or your peace of mind. Click the next video and see you over there. I am Guy DiMartino, meeting you at the intersection of law and medicine. Have a great day.